So let's talk about Edgecomb. How much of it did you get to watch on Nick's channel?
About 50%, but I got the parts that matter, let me tell you. And I could probably combine it with you, and we've got 100%. Because, for example, I did miss the closings. I'll admit that. But other than that, I saw what I needed to see, and certainly I saw his testimony, which that was all I needed to see to judge reliability and to judge what happened in that case and whether it was truthful or not truthful.
Yeah, that was the. I have a lot of things that I can say about that testimony too, because it's like, on the one hand, there are nerves, I'm sure, that exist for any defendant taking the stand, and it's not always recommended that a defendant take the stand in any case. But sometimes you kind of have to, like Natalie Wisco talked about it quite a bit on this channel about Kyle Rittenhouse, how they determined that he really needed to for legal reasons, because the nature of their defense required that he give some kind of testimony about his state of mind, basically. And so anyway, but in this case, I mean, in any case, you really run the risk. And in this particular case, it was terrible. It was terrible, terrible, terrible. I don't know if maybe they just didn't prep him well enough, or maybe they prepped him and he either didn't retain that preparation or just decided to ignore it or something. Because, like, you can from time to time, there's being a difficult witness, and then there's being an impossible witness.
And that's, by the way, that's exactly what I said the other day. That's exactly what I said. And I was asking other attorneys, and I was also on with a lawyer, and I asked him the same thing. I said, a lot of people have brought up this prep thing, but I have no idea what he was like as a client. None of us do. And everybody, and it doesn't matter whether you're a litigator or do transactional law. There are easy clients and there are difficult clients, and they are two different sides on how to handle them. There's some clients that say, hey, whatever you tell me, let's do it. Let's do whatever you say. I totally trust you. You do this. And there are clients that essentially
Alec Baldwin.
Yes, Alec Baldwin. They do whatever they do, and they expect you to defend them regardless of what they do.
Yeah.
And I can see Edgecomb being, like, if there's an average client, I can see him being closer to difficult than closer to easy. He's on that side of the spectrum. I can tell. You can see it in his personality. He also thinks he's clever, based on his responses and based on that strategy he was employing. I think he thinks he's clever.
Yeah. Yeah, in the same, I mean, he had the same strategy as the Kindry brothers in the Rittenhouse trial. Every other question, his response was, can you repeat that? Can you repeat that? I don't understand. Can you repeat that? And it's something that you can, if we're talking about strategy of a witness, making things difficult for the lawyer that's doing the cross-examination of them, like, you can do that every once in a while, but when you do that every single time, everyone starts to see through it. And then you've got 12 objective people that are looking at you and saying, okay, you clearly you're just obfuscating. So what are you hiding? So then they start framing all of your testimony under this question: what are you hiding?
So you think it was a bad strategy for him to do the, can you repeat that thing, and the same statement of, oh, I was acted to defend myself, even when it was like totally irrelevant. It was like, did you throw the gun out the window? I acted to defend myself. I'm like, from what, the window? Like, what? That's not the question. That was literally
the window was attacking me. I was defending myself.
It looked really racist. The window looked super racist. It's like,
I just, I think it was a terrible strategy, because at the same time, you also have, I mean, where a cross-examination can sometimes get boring, like Rittenhouse, for example, that cross-examination got boring. It was so long that I would imagine that the jurors' minds were starting to travel after a while. And that was one of the reasons why, Natalie Wisco told me, that was one of the reasons why they didn't object really during his cross-examination, even though there were plenty of questions where they probably could have, should have, but but they made the strategic choice not to do that specifically because they didn't want to call attention to the question, because they could tell they were
Which
watching the
is
jury.
what we were saying during the trial. We're like, seems to be a strategy to give minimal objections to, number one, speed through it, to minimize it, and seem like they have nothing to hide. I mean,
Exactly.
I mean, ultimately with Rittenhouse, we can dislike it, we could comment on it, but they got the W, which frankly is all I care about. They got the intended outcome. So thumbs up for them.
Yeah, no, absolutely. And the in this case too, essentially what he's doing by asking the state to repeat the question over and over again, where the jury might have started to wander, they're getting recalled for them to have the question asked for them as well. So then they're like, oh, okay, now I know exactly what this question is again. And you said what? Okay, now I'm really interested in your answer, because he's asked this question several times. Now I really want to know the answer. Answer the damn question. So it's one of those things that it actually calls more attention to his testimony that he really doesn't want to give, apparently, or at least that's the signals that he's giving off.
Yeah, absolutely. But I guess the one thing I think about here is, and this is the real fundamental question, and I'm interested to see what you think about it. Did this strategy work? Because here's the real question of the Edgecomb case. Who won? Did the defense win, or did the prosecution win?
I mean, it depends on how they were framing wins for themselves.
Exactly, because
you can go into a criminal defense case and say we absolutely are not going to win this, but at least we can try to reduce your sentence.
Exactly. We don't want the first degree intentional, but the reckless we're happy with. And it seems like it would be a reasonable strategy in this case, especially with the facts being so bad, so many witnesses against Edgecomb. Edgecomb did have ultimately a lot of facts and witnesses and evidence against him. And because of that, they may have realized that this is a compromise. And even at one point during the motion practice, something that kind of tipped its hat to this was the fact that the defense, when they were talking about the self-defense instruction, they hinted that they would be happy with an accident instruction because, that kicks off the first two charges, and they want to get rid of those charges. That's when Judge Hawkeye, dropped in and was like, I'm tired. I'm going to kill one of you two. He literally, I think he said that. It's like, I'm going to kill you. I'm going to kill the two of you, because, they're just going back into like a pretrial fight. They're like trying to regress this over something that happened at trial. And I think that they can frame it like B. Ivory can frame this as a win, can say, hey, they didn't get this, we got this. But yet somebody in the chat says BLM can still, take this as a systemic racism, blah, blah, blah. They have their narrative. And the prosecution can say, hey, we got a guilty verdict. Like there's justice in a guilty verdict. So we got
this guy's going to jail for multiple decades.
Yes, more, but he may see the light of day before he dies. He may not die in jail.
Yeah. Yeah. Which, I mean, if you look at it from the perspective of what a prosecutor is supposed to be going for, they're supposed to be seeking justice, not convictions. So that for them, they may see that as justice actually being served, if they didn't get the top conviction, but the way in which the facts laid out, they still got a conviction, and that, the public will be kept safe, I guess, from their perspective. That could also be seen as a win for them too.
Right, exactly. And I mean, Edgecomb was also committing other crimes. Let's be clear. That was brought out at trial because of his own incompetent testimony that he absolutely opened the door to allow that evidence in. And by the way, shout out to the ethical prosecutors. These guys were ethical. They could have pushed it harder. They could have pushed it further. They could have had him read out the actual criminal complaints, the actual charges. He opened the door to that by saying that he didn't know that he had criminal defense attorneys. He didn't know where he was. He didn't know what he was doing.
And the whole answer to that, like if he was saying, because it seemed like the reason why the state was asking him, like, okay, you had two other attorneys that were representing you, right? Like the whole reason why they said that in the first place was because he was like, well, my whole reason for why I was gone for 6 months and why, I I eluded the police for 6 months was because I was looking for representation. I didn't have money for representation, so I was trying to get myself in front of family and, like hardship. Like, but you can still have that and have these other two attorneys that you have already retained for other purposes, and not get into those details. You can say, yeah, this is why I needed money was because I had representation in a couple other matters, and that, that is a financial hardship. I feel like anyone could understand that, right? Like an objective
Yeah.
person on the jury would understand that. Like, okay, so all right, fine. Like even if it's not the best argument, you could still buy it. But as soon as then it starts unraveling and he gives more and more details about like, oh, but I didn't know that they were criminal defense attorneys or something, or they weren't really criminal defense attorneys, or
And then the
it's
whole thing
just,
about the public defender thing, and I've got on this on multiple streams now, that was insulting to public defenders because, in fact, not only are there are always good lawyers and bad lawyers, there's always good public defenders and bad public defenders, but there are some, especially the experienced ones, because they don't give you the rookie when it's a murder case. They give you
Yeah.
the most experienced, gray-haired, talented attorney because they know how serious it is. You're going to get
Yes.
the best one. The Halderson ones were the Halderson people were public defenders, by the way. But when you get these people, they've got more trial experience than almost anybody out there, and certainly the majority of local defense attorneys. So this whole distinction between public defender and local defense attorney was disgusting. I don't like it. I don't like that they did that. Yes, it's something that people do think, but it's, people also think stereotypes that are completely racist or bigoted or horrible, but we don't necessarily say them. It's something that you don't need to put out there, especially when it's total bunk. It's total BS.